Well, I think the first thing that we were all curious is, did the judge or anybody have any reason not to explain what was going on? Do they owe it to the gallery? Do they owe it to the other people in the courtroom to sort of say what is going on?
Well, I think the first concern, certainly of the judge, is the integrity of the process and making sure that the jury has the opportunity to deliberate without any kind of pressure or without anything. So it's hard to know what was going on. It could have been something very innocuous, or it might have been something personal to one of the jurors. Maybe a juror was sick. Maybe the juror had a sick relative and wanted to leave early. So I think whatever it is will ultimately be put on the public record, and the public will know. The view, I'm sure, the judge is the public has a right to know, but not now.
Because it seemed at first, it seemed like the defense was thrilled that whatever was happening seemed to be coming down in their favor, and then an hour later the prosecution seemed to think it was going down in their favor. They brought Bulger in and out of the courtroom maybe 4 times, which seems a little bit chaotic.
Well, I think, you're always concerned that if something is going on which has a substantive impact, whatever it might be, that the defendant is present. That's typical. So unless it's something purely procedural, the likelihood is the judge is going to bring the defendant in, because you want to avoid an issue on appeal, which is my rights were given away, I wasn't even there, I didn't even have an opportunity to speak to my lawyer about it. So the judge is always going to err on the side of bringing the defendant in, and it's a little bit chaotic and it's nail-biting time, but that's sort of what the jury process is all about.
Okay, so then late in the afternoon, there were some questions that the jury came forward with. They wanted to know about whether you had to have an unanimous verdict on the racketeering charges. And then the prosecution wanted to say, oh, well, let's explain to them that they only have to convict on 2 of these racketeering charges. And the defense said, no, that's not necessary. And then I guess he eventually conceded and said, okay, go ahead.
It's hard to put yourself into the position of the thinking of the lawyers who, after all, tried this case for, 2 months, lived with this case for a lot longer. So the statement of the law is correct, which is you only have to be unanimous on 2 of the predicate acts. The jury, for example, could be unanimous on predicate act 5 and predicate act 7. That would make him guilty on the RICO count. And they could disagree or be unanimous against the government on the others. I don't know what was going on. I think that was a correct statement of the law. My guess is that the reason that the defense lawyers in the end said, oh no, let them know that it's only 2, is, remember, their play at this point is jury nullification. That's what their theme was to the jury in the closing argument. So I think they almost wanted the jury to know, don't give up the 2. If you're that one holdout juror, if you're in there and you're fighting for us and you're going to say not guilty on all counts, don't think that by going guilty on 2, you're somehow doing us a favor. That's what I think is probably the thinking of the defendant.
Explain jury nullification for a minute, because as I understand it, it's like you have enough evidence to convict the guy, but you don't like the way the government has presented the case.
Or you think the law is unfair. I mean, it's not really accepted in the law. The jury is the judge is never going to instruct them. And I think both Jay Carney and Hank Brennan were very careful. They didn't use that word. They talked about how you're an individual citizen and you have to speak up and you're the the last bastion of democracy. So they didn't use the word jury nullification. I'm not sure the judge would have let them use that word, but the concept was there, and the theory is that the protector of democracy is always the conscience of the jury, and all it takes is one member of the jury to say, no way am I going to let this guy get convicted, and of course then the jury's hung. The defendant is trying this case for that one juror.
You said earlier in the week that you thought it was going to be fairly quick. I'm sure you've seen that packet they have to go through. Do they do it very quickly? Do they do it pro forma, do you think? Or do they look at each one of those? Because sometimes it's one line and then a category of 15 things under it. Agree, disagree, agree, disagree. So can they do that quickly or not?
Well, it depends on how quickly they reach a judgment. I don't think, this is, I don't know what people's expectations are, but remember the closing arguments took 7+ hours. Why are we surprised that this is the first day of jury deliberation and the jury hasn't come back with its verdict? I'm not surprised at all. Now, my personal prediction is probably by the weekend, they're going to come back with a verdict. It could be as early as tomorrow, I think. But if it spills over even into next week, there's a very long trial. It's very complicated evidence. In my experience, Jurors take their role very seriously, whatever their level of education, whatever their background. This is a high civic duty that they're performing, and they take the job very seriously.
All right, Don Stern, thanks for coming tonight.
Okay, you're welcome.